A woman named Hostilia stands in a private home in Rome, 2nd century CE. She has been accused of adultery. She will not see a judge for 17 days. During this period, she is in custodia, the Roman legal term for custody. She is not in a prison. Rome does not have prisons the way later empires will. She is in the home of a private citizen who has accepted legal responsibility for her body until trial. The state has authorized this. What happens during those 17 days is not recorded. What the law permitted during those 17 days was. Execution would have been simple. What Rome designed instead was a gap. Under Roman law, a woman awaiting trial was placed in the custody of a guarantor. This was not protective, this was administrative. The guarantor was legally responsible for producing her body at trial. How he kept her, where he kept her, who had access to her, the law did not specify. The gap between legal authority and physical reality was where the system did its work. The guarantor was often male, the woman was always vulnerable. The arrangement was called free custody. The term was not ironic, it was procedural. The law recognized 3 types of custody: custodia publica, custodia libera, custodia militaris. Public custody meant confinement in a government building. Free custody meant confinement in a private home. Military custody meant confinement under a soldier. For women, the distinction mattered less than expected. All 3 forms required the same thing: surrender of movement, surrender of appeal, surrender of witnesses. A woman in any form of custody had no legal mechanism to report what happened while she was held. The trial would address only the original accusation. The interval was invisible. Free custody required a guarantor to swear an oath before a magistrate. The oath concerned production of the body, not preservation of it. If the woman died in custody before trial, the guarantor paid a fine. If the woman was returned alive but injured, no law addressed it. If she was returned pregnant, no law addressed it. The interval between accusation and judgment could last weeks, sometimes months. The guarantor's home was legally sovereign space during this time. A woman named Hostilia was held in free custody in 186 BCE during the Bacchanalian investigations. Her guarantor was her husband. The law permitted this. When she was produced at trial, she could not stand without assistance. The record does not explain why. The trial proceeded. She was convicted of participation in secret rites. The penalty was death. She died in custody 3 days later, before execution. The official record lists the death as occurring while in lawful restraint. No inquiry followed. The husband inherited her property, the case closed. The system required no cruelty. It required only time and isolation. Women accused of crimes carrying the death penalty were held in different conditions than men. Male citizens accused of capital crimes could choose exile before trial. Women could not choose exile. They could not leave Roman territory without a male guardian. The law that prevented their escape also prevented their flight. So they waited, in custody, until trial or until death, whichever arrived first. For enslaved women, the gap was wider. An enslaved woman accused of theft or conspiracy faced interrogation under torture. This was mandatory, not discretionary. The law required it. She could not testify in court without it. Before trial, she was held in custodia publica, in the lower chambers of the Tullianum or in the cellars of the urban cohort stations. These were not designed for long-term holding, they were designed for interval. During the interval, she was examined. The law specified that enslaved persons could be tortured to produce testimony, but it did not specify when the torture began or what methods preparatory examination could include. A woman locked in a cell beneath the forum could scream. No law required anyone to respond. The Tullianum was not a prison, it was a waiting room. Its lower chamber was accessed through a hole in the floor of the upper chamber. Prisoners were lowered by rope. Once below, there was no light and no exit except the rope. The chamber was 12 feet by 12 feet. The women held there left no names in the official record. They left measurements, age, origin, physical condition upon arrival. The condition upon departure was not always recorded. Private guarantors were not required to maintain standards. They were required to maintain possession. A woman in free custody had no right to visitors, no right to send messages, no right to appeal her conditions. She was property held in trust. The guarantor's authority over her during custody was nearly absolute. If she became pregnant during custody, the child was born into her legal status. If she was a slave, the child was enslaved. If she was a citizen, the child was illegitimate. Either way, the birth was not grounds for release. The trial date did not change. A clerk in the praetor's office records a case from 173 BCE. A woman held in free custody for 41 days gave birth during custody. The infant died within hours. The notation reads, "Custodial guarantor reports natural death of infant born to accused in free custody. No impediment to trial schedule." The trial occurred 3 days later. The woman was convicted of poisoning her husband. She was strangled in the Tullianum the same afternoon. The record of her execution does not mention the infant. The record of the infant's death does not mention the father. For non-citizen women, custody functioned differently in name only. A peregrina, a foreign woman under Roman jurisdiction, had no right to trial in the same courts as citizens. She could be held indefinitely while magistrates determined jurisdiction. This process had no time limit. One case survives in fragmentary court records from Asia Minor. A woman from Pergamon was accused of sedition in 88 BCE. She was placed in military custody in Ephesus. The Roman governor noted her arrest. The next record of her case appears 14 months later, when a new governor requested clarification on her status. The response indicates she had died in custody 8 months prior. No explanation is recorded. The governor's inquiry was not about her death. It was about property. She had owned land. The case was closed when her estate was assigned to the provincial treasury. The system did not need to be cruel. It needed to be slow. If you are beginning to see the machinery beneath the myth, there is more the archive holds. This was not anomaly. This was architecture. Subscribe to Hidden by Time so the next examination reaches you. Women condemned to death faced a different custody problem. Roman law prohibited the execution of virgins. The prohibition was religious, not moral. A virgin's death would pollute the executioner and the state. So a procedural solution was found. Before execution, a condemned virgin was married or raped. Both solutions appear in the historical record. Both were legal. The rape was performed by the carnifex, the executioner, or by a designate. It occurred in the Tullianum or in the Carcer. It was not documented as rape. It was documented as preparation for lawful execution. The case of the daughter of Sejanus provides the clearest example. In 31 CE, Sejanus, the Praetorian prefect, was executed for conspiracy. His young daughter was condemned to death alongside other family members. She was a virgin. The law could not permit her execution in that state, so she was raped by the executioner before strangulation. Tacitus records this without comment. Dio mentions it briefly. Neither historian frames it as exceptional. Both frame it as procedural. The word used is not rape. The word used is necessary preliminary. The execution proceeded. The record closed. This was not an abuse of the system. This was the system operating as designed. Women in military custody faced similar mechanisms with less documentation. A woman captured during the Social War in 90 BCE was held in military custody for 6 weeks before being sold into slavery. She was pregnant when sold. The record does not indicate if she was pregnant when captured. The purchaser complained to the magistrate that the pregnancy lowered her value. The complaint was dismissed. The sale stood. The documentation gap was structural, not accidental. Roman legal records documented accusations, trials, and sentences. They did not document custody conditions. A woman could be held for months, and the only record would be two dates: entry and exit. What happened between those dates was not legally relevant unless it prevented her production at trial. If she arrived at trial alive, the custody was lawful. If she arrived injured, the custody was still lawful. The injury was not part of the legal question. Some women never made it to trial. A woman named Sempronia was accused of conspiracy in 63 BCE during the Catiline affair. She was placed in free custody. The guarantor was her cousin. She died in custody before trial. The official record states, accused deceased prior to examination. Case resolved by death. No trial required. Her property passed to her cousin. No investigation occurred. The historical record preserves her name only because Sallust mentions her in his account of the conspiracy. He does not mention her death. He mentions her parties. For every named woman, there were dozens unnamed. For enslaved women, foreign women, poor women, the record is nearly blank. They entered custody. The record shows this. They exited custody. The record sometimes shows this. What happened between entry and exit is silence. The silence was policy. By the late Republic, the system was so routine that abuses were not prosecuted because they were not recognized as abuses. A woman held in custody and raped by her guarantor had no legal recourse. She could not testify against a citizen in court. If she was enslaved, her testimony required torture. If she was a citizen, her testimony required a male sponsor, often her father or husband. If the rapist was her husband or father, the legal loop closed. If the rapist was her guarantor, he could simply deny access to her until trial. After trial, if she was executed, the question became moot. If she was acquitted, raising the issue would damage her reputation more than his. So they remained silent, and the silence was built into the procedure. The system did not need monsters. It needed bureaucrats. It needed magistrates who signed custody orders without asking where the woman would be held. It needed guarantors who accepted responsibility for bodies without accepting responsibility for welfare. It needed clerks who wrote, "died in custody," without asking how. It needed a legal framework that defined custody as an interval, not an experience, and it needed time. Time for memories to fade, time for witnesses to disperse, time for the accused to weaken, time for the record to close. Thousands of women passed through Roman custody over the centuries. Most left no trace, no name, no crime, no trial, just the gap. The gap between accusation and judgment. The gap between law and practice. The gap between the record and the real. That gap was where the system did its work. Quietly, legally, repeatedly. Rome did not need to break its own laws to break the women in its custody. It only needed to follow them, hidden by time.